anything does that have to do with this particular case? And is there kind of like a history going on here that maybe we all should be aware of?
I had evidence that was being excluded from a court case, and I figured out I had a constitutional right to present it, and the court decided I did not. And so, you know, I guess that's where I stand on that, is if your constitutional rights are being violated, you need to have enough gumption to stand up and do something about it. And so, you know, you've seen what happened when I first started standing up, but did it deter me? No. Here we are, and part of what the grand jury is investigating is about what all happened to, you know, what happened leading up to all that. So.
And the importance of the grand jury, why is it so important that these the grand juries continue their investigations?
Well, if they don't, government will get away with anything they want. Government will not investigate itself. And so our grand juries were written into law, or into the Constitution, to be the citizens' way to investigate government when government will not investigate itself. That's it in a nutshell. And if we lose that, government will just keep twisting the rules like we've been seeing them do it, until pretty soon they can do anything they want and they'll never get in trouble.
Well, thank you, David. I really do appreciate your time here this morning. It is great again to see such a large crowd here out for this trial today.
Oh.
And again, this is State of Alaska versus ex-Judge Margaret Murphy, and the deep-seated corruption that was within our judicial branch here within our state. Thank you.
Okay, thank you. Yeah, I guess.
How you doing, man?
Alrighty, guys, you guys all heard it here live. Thank you for being here. Again, like, share, find us on Twitter, YouTube, Facebook, Rumble, all of your favorites.
No, look at me. Look at things are right.
Oh, yeah. Well,
They're good friends of mine.
yeah, well, appreciate it. Yeah.
Under the Alaska State Constitution.
Just the physical distance. Well, we're not friends.
Trying to prevent those investigations because there seems to be something to hide. Why would you just stop the investigation? Why would you?
So we're acquainted to each
right
other.
of the people have a checks and balance on the judicial system or the legislative process or anything. When the court hides something, it's because there's something to hide. If there's nothing to hide, you open up the investigation. Why is the grand juror's report from this summer not been released?
Since we'll know more, would you be interested?
Appreciate you, bro.
Yeah. Yep.
Since we'll know more.
Yep. Oh, okay. All right. Well, thanks again, and I'm going to probably run into the courthouse here, I guess. Okay. This is what's going on.
Yeah, I'll probably pop in later, but I think for the most part I'm just going to hang out.
There's a 26-unit
Oh, okay. That'll work.
And his wife's
Well, I'm going to, Thomas, I'm going to go into the courthouse. Should we wrap this up then and go in?
Yeah, we can do that.
Okay. And I don't know, I brought...
I'm going to take what I brought, and then
Okay.
we'll leave what you got with you.
Yeah, we'll just put them in the truck and go in and watch the hearing.
Yeah, I think that's what I...
Okay.
These are names of mine.
Okay. Well, I don't know if people are going to stay out here or everybody's going to the courtroom. Okay. Hold
doubt it. I don't know, I doubt it.
You guys want belts too?
No, you don't have to.
Really on the right off like
Go ahead now.
Oh, the jumping, that's it?
No problem.
Pizza? Okay, you're good. Walk through. Thank you, ma'am. We got one side right now. Walk through.
Your jacket as well.
Jacket.
It is warm.
Go ahead.
Which is it? Where is it at? You know where it's at? Second floor. Second floor. Huh?
I'm not afraid of germs.
I guess we'll just follow everybody else, huh?
I don't know.
Thank you, sir. Walk here. Thank you. Scott?
We already get on it.
I think you already went out.
Yes, we're gonna go to the basement.
Is that where it's at?
No.
I love it.
401, isn't it?
Come on in, come on in.
It's
come
what,
on in.
401? I think 401.
Yep.
The guy at the back, older, old folks walk slower. All right.
I just hope they get to the hospital.
Doors closing. I'll never forget it. One of the hospitals in Houston,
I know.
the guy cut his head off.
That's
Yes.
that's gross.
Yeah, that was
Why
at the
talk about
hospital. That was during the big
It was a
flood.
resident.
Yeah.
Scott, your bag's in the way.
No, I'm not. I'm bags in the front this way. This door's just honoring. I think it's your coat. Yeah.
It's my coat.
See, there you go. False accusation.
My phone.
Careful that there's cameras.
Oh, that's okay.
Transparency, right?
They also
That's why we're
get.
here, right? Transparency and accountability.
Yep.
Yeah. Guess that's why I'm here.
Once I get set up, I'll let everybody here. Any members of the council or media here present?
Media.
Media, come on in.
Eric, going in.
Media and council.
Here, let me get on this side over here. Good morning, sir.
Hey, Tim.
Good morning.
How are you?
Good, thank you. How are you?
See the greeting committee?
I'm sorry?
Okay, you want to just move that front? That's the case here.
Oh, look at you.
I know, you're all dressed up. I know you got your little hugs or whatever on your bellies.
It's going to be in the jury lounge, yes. We'll have you guys set up.
No, of course, they're under the thing.
And you're here for, okay, and Yen?
So you want to sit,
Jake. Yeah.
okay, so we don't, in case things get rowdy?
Yeah. Yeah. Yep. Okay. And then where are you guys here with? Okay, it's okay.
News in Alaska.
Okay.
She's coming.
Give me a few minutes to-
And you guys can set up on that side as well.
Okay, I might have someone grab me a tripod, actually.
Okay. For media and council only for now. And I'll be opening
Do you like running to the truck and grab my bike?
media and council only for now.
We're gonna let me in there.
Anybody else?
If you could, that'd be great.
Okay, he was with you.
He's with me.
Okay, you guys can come in. And folks, once we get set up, we'll let folks in.
News in Alaska. News in Alaska.
KTU, ADN, and who are you with?
I'm Validity.
I'm sorry?
Validity.
How do you spell
VOLITADICK.
it? And have you already had a media request submitted? and
I
approved?
did, but it was before we were able to actually stream now.
Okay, so the judge has signed off on it.
Not on streaming, I got pictures, I was allowed to do everything.
If it's
but-
pictures and other resources besides some streaming, then we're gonna have to get approval from the judge.
Okay, let's get the approval done
Have you
because,
filled that form?
I did fill out a form except for,
No, I can certainly not for you too. Yeah. And are you also with the same?
What's that?
Who are you here for? Did you submit a media request and get one approved by the judge presiding over the matter today?
I didn't think we needed one.
Oh, you're definitely gonna need one. So if you haven't filled out a media request form, you're gonna have to get that one
It
completed.
still needs to be approved.
Yeah, this one was approved for KTU. Yeah, you're all set.
Thank
So
you.
if these guys are allowed in here, why am I not?
It's because they filled out these forms ahead of time.
We have the First Amendment right to film in here.
No, you're gonna have to, not for the courtroom proceedings because they need to be approved by the judge presiding over it. So I can get you you a blank form if you want to fill it out right now.
Yeah, I don't think we need that.
You will need
We
it,
have a
sir.
First Amendment right to film.
No, you will not be able to film unless you have an approved media request.
I don't need to prove media request.
I'll tell you right now, you do.
I don't.
You do.
No, I don't.
If not, then I'm going to have to ask you to leave.
You can ask.
Just go get the form.
I'll get you the form to fill out.
Just fill out the form.
Yeah.
It's against our Fourth Amendment right.
No. You won't be able to film until you get that form completed and filled. That's court system policy.
Okay, well, let me see one.
Supersedes the
That's right.
First Amendment.
Rules of the courthouse supersede the First Amendment.
When they have certain rules or laws that have been put in place within the courthouses for being able to do media, you have to get permission first. Because there are cases in here that are not for public.
We're only here to see one case, right?
If you want to report on it, just get the form, because I'll tell you, every news is better than no news.
He didn't have contempt.
So, yeah, but we had so much.
Yeah.
Especially when you.
Yeah. Yeah, oh, totally. That was, there was a lot of secrets.
Oh, yeah, I actually got into it with some of them. Yes, yeah. Well, it's really. Anyway,
Yeah.
we're looking forward to it.
Yeah. Did you guys get that?
No.
So, Tim, did you get that?
Yes, I did. It just take some time to complete it, and then I'll just need this top portion. And then I'll get it to the judicial officer. So feel free to flag me down if you're ready. There's a table right there.
That's all right, thank you.
Oh, because of the Alaska Airlines or something?
Oh my God, I've never seen you without a hat.
Yeah, that's fine. I wanna find out from Jeff when the, yeah. Oh, no.
Because, I mean, it's not that bad.
My wife couldn't get up this morning, so that's.
So
when is the date that
He didn't, he just said later in the month. I wrote him back and said, I'm leaving the country a week from tomorrow, and it has to be before then. Because I won't. So, I'm happy to accommodate him, but Central Patrick's too big.
Yeah.
Well, so is he gonna do it in there, maybe?
Today, he's doing it, yeah.
No, but then tomorrow, if he can't make it up to Alaska.
He'll have to, yeah. What he wants, said he wants to be here, so I wrote him back and said, I'm happy to accommodate you, but.
What is it, 8th?
Yeah, that's right.
Do you think
Monday.
they may take that up at the minutes?
No, I don't think we're gonna talk about that.
Well,
No,
I know
no.
what he would say is counsel regarding the other scheduling or something like that.
I don't think we're gonna come up, you should.
No, he could, send people out and talk about it.
Like 10 minutes. Okay, so it's not even.
He got plenty of time. that's fine.
Yeah, but when you said you're leaving tomorrow or the following? A week from Tuesday, okay. Yeah, we can,
Do I need to fill that out?
No, if you filled one out and it was approved before, you won't have to fill it out.
It was approved, just that was when they were limited to what then and now. Okay.
Okay. Oh, was it just for a specific hearing?
No.
Well, no, it was for all.
For all hearings, that was a request? Okay. Then you should be fine.
I do, yeah.
Yeah, but I do that.
Is that a good number? Because I'll need a good contact number, because if not, we won't be able to let you know that it's approved or not. Right. and I haven't marked the doors, so I have a number of folks coming in once I get these requests processed. Okay, that should do it, all right. Until it's approved, here, I'm just gonna hang tight for me. Okay, so feel free to grab a seat if you need to.
I think we can get this thing. I mean, he can get it.
Yeah, no, of course.
I know, I don't. Yes, absolutely.
Ever since I one time
It was I think it's that simple. That is. Well, you know what it was, though. He was trying to, Hi, I'm Deborah Fitzgerald. Nice to meet you. Yeah.
Creed is the best person on this.
No.
Despite the poor training.
Looks like the judge approved, you can go and sit in the box. But in the future, make sure to fill out the request form.
Is this just for the courtroom or the courthouse?
Just for the courtroom, and this is for this proceeding only.
I'm sorry, I have a bad hearing.
Look, just for the courtroom and just for this proceeding.
Okay.
So feel free to sit over in the box.
Okay, thanks.
That's why I'm gonna have to let folks in, so. Yep.
Unfortunately for her, Jeffrey Johnson, now she's not.
Much better. Along with.
So I always, I give you these things.
Oh, and all gentlemen, please hats off in the courtroom, please.
Can I sneak behind you? If you can take a seat, I'll stand. Hold that, hold me for a second. All right. Thank goodness.
Looks like we got a full house today, folks, so if you can make space on the benches for everybody so they can get a seat, please do so. One more spot there, and one more in front. Go ahead, any parties on this conference line. Council of record, ready to proceed? We're ready. Mr. Campion, were you ready to proceed?
I am, thank you.
Thank you. All right, Superior Court for the Third Judicial District. That's now in session. The Honorable Judge Thomas Matthews presiding.
Good morning, everybody. Thank you. Be seated. Welcome. On record? All right, good morning, everybody. We are on record. Did we get the live stream started? Okay. All right. Bear with me for a moment. I got it right here. Thank you. Those who've been to these hearings before will remember that we are live streaming and it takes a moment to get this actually set up, so. Just a moment. All right, good morning again, everybody. We are on record in the matter of State of Alaska versus Margaret Murphy, case number 3HO23-00295, criminal My name is Judge Tom Matthews. We're here in Anchorage today. This is time set for oral argument on a motion to dismiss. A couple of preliminary comments for the parties. First, for those in the public gallery, you'll note that we don't have anybody seated at the other table today, at the other council table. Mr. Campion, the independent prosecutor, was stuck unfortunately because of the airline cancellation, so Mr. Campion is on the phone today. Mr. Campion, can you hear us okay?
I can, Your Honor. I just wanted to advise the court, I'm getting feedback. I don't know if that's happening in the courtroom or just on the phone.
It's in the courtroom as well, so I'm going to ask folks, if you are listening in on the telephone line, if you would please mute your phones. And that seems to be much better. Thank you, everybody. So once again, by way of introduction, this is a motion hearing. We're not here to take evidence today. I'm not going to be hearing from witnesses today. This is a time set for lawyers to make arguments to the court based upon motions that have been filed. This is a situation where in every case, citizens, including Alaskans, have the right to have felony charges reviewed by a grand jury under both the federal and state constitution. And an indictment is a statement of the charges against the accused. It is the right of every criminal defendant to have those charges reviewed by the grand jury as a preliminary step in the process. That indictment is simply a determination by a group of citizens that they've determined there is sufficient evidence of a potential crime to move forward. The Constitution, both under federal law and our state law and our court rules, provides for that process. Equally important, though, is that a criminal defendant has the right to challenge the legal sufficiency of the indictment and ask a judge to make a determination that the process was conducted in accordance with established legal principles. Motions to dismiss an indictment are a part of the regular criminal proceedings before the court, and that's what we're here to address today. I will tell you also at the outset that these are important decisions, and it is not my intention to make a decision today. I want to weigh the arguments of the lawyers, reread the briefs, and make sure that I am clear exactly what the parties' positions are and understand exactly what the arguments are. So I will not be making a decision on the record today. I will issue a decision in writing after I have thoroughly reviewed the record. So with that said, we have lawyers on the defense side, Mr. Patimenos, Mr. Robinson, who is going to be arguing today.
Mr. Patimenos will argue the motion, Judge.
All right, Mr. Patimenos, are you ready to proceed?
I am ready to run.
You may begin. Thank you.
May it please the court, Mr. Campion. Sword and shield. That's how the grand jury has been described since time eternal. Sword because it is a powerful tool of law enforcement. You can't, as a lawyer, go inside the grand jury on behalf of your client. The grand jury has enormous powers to subpoena, to retrieve documents, to grant immunity and compel testimony. It has brought down cartels. It has brought down public corruption. It has brought down the mafia. It is an awesome power. It is a sword. But it is also a shield. It is a shield because in our founding fathers, the king could charge anyone he wanted. And the shield is putting the citizens between someone and an indictment. Because an indictment, whether you are later exonerated or acquitted, will change your life forever. So we no longer live in a country where the king can indict you. It must be a grand jury. Because of the shield function, there have been guardrails, strictures, limitations about the quality of the evidence that can be received so that the shield has a purpose and a strength and a function. So the grand jury, which constitutionally has the power to investigate and which shall never be suspended, investigate is a neutral term. It is a neutral term because it is both the sword and the shield. When a grand jury investigates and exonerates someone, it is every bit as important an investigative function as it is to indict. Different governments have emphasized the sword and shield in a different way. In our state, great emphasis has been placed on the shield function of the grand jury. For me, this is a return to the beginning of my career, because I was the first special prosecutor ever appointed in the state of Alaska in 1978, where I served in the special prosecutor's office when it first opened under now Judge Mahalski. I probably convened more investigative grand juries than any lawyer alive. I was designated as a special United States attorney and had the option of conducting investigative grand juries both in the federal system and the state system. Therefore, it was with great interest that I circled back at the beginning of my career when this assignment came my way. The first thing I noticed was the indictment itself. It says that on or about November 3rd, 2022, at or near Homer, 3rd Judicial District, Margaret Murphy committed the crime of perjury. And that's all it says. When I first read that one sentence, not 5 seconds into the case, I was bewildered. When I first came to the special prosecutor's office, I had the opportunity to be sent to the Cornell Institute of Organized Crime, where we were taught and trained how to conduct investigative grand juries. We were put in a scenario like what most lawyers go through in the National Institute for Trial Advocacy, where you learn by doing, and you're placed in front of a mock trial. We were placed in front of mock grand juries, and we were taught to follow. There's a triangle. When you have a witness in the grand jury who might be part of the mafia, some sort of witness that you had a difficult task to get to justice on, there was a triangle. You either got the truth out of the witness, you set the record for evasive contempt, which is what happens when a witness appears but refuses to meaningfully answer the question, or you set the testimony up for perjury. And we would do those drills, and experienced prosecutors would watch us, and they'd say, do you think you have it? Do you think you have evasive contempt? Do you think you have perjury established? Well, let's take a look at your question. Let's take a look at the answer. Let's make sure. Nope. Try again. And the reason is, we were taught that perjury is a technical offense that must have a specific question, a specific answer. They must relate, and evidence that proves the matter false must be clear. So it was something to practice. So when I read this indictment, which says nothing, it says not what the testimony was, and says nothing about why it was false, I was bewildered. I thought, what has happened? Has the law changed? Did my education get legislated away somehow? So I dug into the law. And in an unbroken chain of precedent since 1890 and before, nothing had changed. The law requires specificity with respect to perjury indictments, which clearly delineates what is the testimony at play, why is it false, and give the defendant notice of what you're talking about. So now I was thinking, well, the law is the same, and this indictment says nothing and complies in no way with any of the law. What in the world went on here? So then I delved into the grand jury record, and I found my answer. On January 30th, after the grand jury had been told repeatedly that it was not in a position to issue an indictment and would not issue an indictment, and that was not its goal, the grand jury suggested that they might put into their report that they thought perjury had been committed by Judge Murphy. They didn't say what, they didn't say what testimony, they didn't say how. That's all they said, one sentence. On April 7th, when Supreme Court Order 2000 came out, the grand jury said in one sentence, we'd like to consider, on April 7th, an indictment. On April 7th, there was no proposed indictment in front of the grand jury to consider. And so the grand jury, after saying that, said to the independent prosecutor, what do we do now? and the independent prosecutor correctly said, I need to draft an indictment. I need to instruct you on that indictment and on the law. And then we will come back and we will consider the indictment that I draft. That was the plan. That was the last day that the grand jury had a quorum. The next proceeding, there were 11 grand jurors, and as the prosecutor himself said repeatedly during the grand jury process, once we get to 11 grand jurors, the grand jury can do nothing. At that point, the independent prosecutor drafted a grand jury indictment that said the only thing that it could say, because he had not been apprised by the grand jury of anything other than, we'd like to consider an indictment. For what? For when? They didn't say. So the indictment that was drafted could say no more than what the grand jury, when it had 12 jurors, said. And he asked the grand jury of 11 to then vote on this indictment in clear violation of the Constitution, Criminal Rule 7C, and the requirements of specificity. And that's the indictment that's before you, and now the mystery is solved. It was done this way because there was an attempt to evade or get past the problem that the grand jury lost its quorum. But the indictment is no less defective for the attempt to get around that problem.
While you're pausing, can I ask you a question?
Of course.
Can that issue be resolved if all 12 grand jurors are reconvened?
No.
And tell me why.
Because of Stern. And because of the record as we have it. And perhaps this is a apt segue into discussing Stern.
But before you get there, let me ask this. I think this was clear, and this may be a question for Mr. Campion, but I want to ask your opinion as well. You have laid out in your brief 4 different arguments as to why this indictment ought to be dismissed. Is it sufficient for the court for me to dismiss or to grant the motion on any one of those grounds, or must I look at all 4?
That's a very astute and important question, and there are layers of the answer. The simple answer is yes. Every single one of these defects by themselves are sufficient to dismiss the indictment. However, it's important for the court to review the record as a whole because the errors are cumulative. What's a good example? Under the Stern test, as the court is aware, you have to make an analysis of whether there is sufficient evidence, apart from the offending evidence, apart from the inadmissible hearsay and the unprecedented amount of detritus that's in the record, and determine if there's sufficient evidence to sustain the charge. But what is the charge? You don't know, because the indictment is defective. As to what testimony do you apply that test? You cannot, because the indictment is defective. On what law did the indictment, even as it was, issue? No instructions. The prosecutor, way back in January, read the term knowingly, explained to the jury that testimony given about events that took place 20 years ago had to be knowingly false at the time it was given. The testimony must be knowingly false. What's the testimony? We don't know. So you can't apply Stern because the indictment is defective. You can't uphold the indictment because the instructions are bad. You can't uphold the indictment because there is an unprecedented amount of material here that had no business being in a grand jury. And there's another reason why I believe the court should address all of the issues. There is a woman named Harper Lee. Harper Lee attended and studied law at the University of Alabama as a woman in the late 1940s. One can only imagine what it was like for Harper Lee to study the law in the 1940s in Alabama. She never became a lawyer, but she probably inspired more young people to become lawyers than anybody you can name, because she wrote a book that we all had to read when we were young called To Kill a Mockingbird. And it is about Atticus Finch, and it's about the honor and duty of being a lawyer in the face of public approbation and pressure from the outside that threatens to destroy our rule of law. And how Atticus Finch held the line and did his duty. Not every case that we encounter as lawyers bring in the concepts that go with To Kill a Mockingbird and Atticus Finch. But Judge, this is one of those. This is one of those cases where it is important for the court to write well about all of this. Because in well nigh of 2 years shy of 50 years practicing law, this lawyer in front of you has never seen anything like it. It is the biggest incursion on our rights to grand jury indictment and to fair proceedings that I have ever seen. And it threatens the very fabric of what it is that our founders stood for when they took the power away from the king. It's a long way of saying, regardless of the technical ability to dismiss this indictment on some narrow ground, on quorum, on the legal facial insufficiency of the indictment, I urge you not to do it. Because there is a judicial function at play here where the judiciary educates, sets precedent, teaches, informs the government as to what it can do and what it cannot do. And while it's not always implicated in the cases we undertake, it's implicated here. This indictment violated the rule that the evidence before it must be admissible. Intentionally inadmissible evidence was introduced in volume. We've attempted to lay some of it out for you. There is much more, it is much worse. And all you have to do is skim the exhibits to the grand jury and you will see the wrong sufficiency of the evidence instruction was given to the grand jury. In fact, the sufficiency of the evidence instruction was the lowest standard of proof that exists under the law, which is far from what's required. The grand jury didn't have the proper quorum. The indictment failed to specify the crime in violation of Rule 7C. The rules that implement our constitutional right and that makes the grand jury a shield were torn asunder. The shield was in tatters. It's too late for Judge Murphy, who now has suffered the consequences of an inappropriate, illegal, and unfair proceeding. But there's a silver lining here. And the silver lining is that cases like this stop the bleeding. It stops the threat and the danger that can ensue. When Supreme Court Order 1993 came out, and the court clarified, and I say clarified because it wasn't new law, that parties elected to nothing by no one do not have the right to come into the grand jury and start the hunt. We are a representative democracy. That means that our representatives, the executive branch of government, is the sole authority to institute charges, and they must take it to the judicial branch. And as the O'Leary case tells us, a grand jury is part of the judicial branch of government. Mr. Campion, though he says otherwise, does not represent them. He is in the executive branch. He is an executive branch agent. All of these concepts, which are fundamental to the shield function of the grand jury, are before the court now. And I believe need to be redressed, reaffirmed, and solidified. Because this is one of those cases. like Atticus Finch and Harper Lee was talking about before she won the Pulitzer Prize and received the Presidential Medal of Freedom for her writings. This is such a case. Subject to the court's questions, I'm done.
Gentlemen, thank you. I may have further questions for you after I've heard from Mr. Campion.
I'll be happy to address them.
Thank you. Mr. Campion, good morning.
Good morning, Your Honor.
It's your turn.
Okay, well, I guess I'll start, Your Honor, by reminding the court that the instructions that I received, the evidence that was presented to the grand jury, the questions that the grand jurors had, and the course of the proceedings are all accurately reflected in the record that has been submitted to the court. Further, my arguments as outlined in my opposition, I won't repeat them. I believe that this time is best used to address Mr. Bituminos's arguments and also to address sort of the intent that led the intent of the grand jurors as I understood it, and my intent as it led to the indictment. Factually, there's very little I disagree with Mr. Bituminos. I think he accurately reflected what happened in terms of the facts, but I think it's important for the court to consider, particularly in light of the record of the grand jury, that the grand jurors were not intending to set up Judge Murphy for perjury or for any crime, that at the time that Judge Murphy testified on November 3rd, 2022, the grand jury wasn't viewing her as a target of its investigation. It was not viewing her necessarily as someone that they expected would be evasive or would not be truthful in her testimony. I think the record is clear that when she testified on November 3rd, she and the grand jurors understood she was testifying about what happened during Mr. Haig's trial in 2004 and 2005. And very clearly, the grand jury was not planning to indict Judge Murphy or anyone else in November 2022. It wasn't until January 2023 when the grand jury received some correspondence between Judge Murphy and the Alaska Commission for Judicial Conduct that there appeared to be a discrepancy between her testimony and what she had written to the commission. And that's what led to the further discussion of potential perjury charges, including the instruction that I provided. Our position is that the grand jury, or I should say my position, is that the grand jury was adequately instructed on the elements of perjury as well as the mens rea requirement. That was done in January. But I can't dispute Mr. Bituminos' comments and argument regarding quorum. The record is clear that both myself and the grand jurors understood that they needed to have at least 12 grand jurors to effectively function as a grand jury. I want it to be known that whatever led to the decision for the grand jury to convene an investigative grand jury all occurred before my appointment in August 2022. And I viewed then, and I've always viewed, that my role was to advise and guide the grand jury through the proceedings. And I think the record shows that I advised them of the potential risks of all of their decisions. I think it's important that when this indictment was returned back in April 2023, I advised the Superior Court at the time that I had very serious concerns about the indictment at the time, and I advised the court to potentially take under advisement whether or not to publish the indictment, because I shared Mr. Bituminos' concerns. Nonetheless, the Superior Court decided to return the indictment without any further review, and it led to where we are today. If the court has a question about whether, for example, if the court were to send this back to the grand jury, whether or not it would be valid, I don't know the answer to that question, but I think practically it's unrealistic. We lost one of the grand jurors, and as far as I can tell, he's not someone that we can find to reconstitute the grand jury, even though the grand jury has not been, their service has not ended. Ultimately, my position, Your Honor, is that I've laid out our response to Mr. Bituminos' arguments. I understand the court has discretion regarding the motion to dismiss. I think it's important for the record to reflect that the pleadings here do not accuse the grand jury of acting with bias, ill motive, or inappropriately targeting anyone, including Judge Murphy. I think the record shows that this is not a matter of myself as whether or not I'm a member of the executive branch. There was no attempt by myself or by the grand jury to set up anyone, including Judge Murphy. And I slightly disagree with Mr. Bituminos that in this circumstance that the grand jury didn't do its job. I think the record shows that these were a group of people who conscientiously heard evidence. They tried to do their best under very unusual circumstances, and they led to the decisions that they made. I do recognize the technical challenges that are presented by this indictment, and I defer to the court regarding this motion to dismiss.
Let me ask you, Mr. Campion, the question that I had posed to Mr. Tuminos earlier, because there are 4 grounds for dismissal that he has laid out in the motion. Is it sufficient for me to grant the motion if I find that any one of those are true?
Yes, Your Honor.
So, for example, if there's no dispute between the parties that the grand jury lacked a quorum at the time the vote was taken, if that's dispositive, it means I grant the motion. Is that your view as well?
Yes, Your Honor.
You have laid out arguments that, well, the grand jury at least heard all the evidence and voted to indict, even though they didn't have a written indictment in front of them. Do you want to expand on that?
Sure. I think I agree with Mr. Patuminos that the indictment itself was not presented on April 7th, but on April 7th, when the grand jury voted, the record shows that they had already been instructed on the elements of the crime of perjury. They had received admissible evidence regarding the potential charge of perjury, and they had a quorum when they made that decision to indict. Mr. Patuminos is correct that they didn't illuminate further, but I think the record is clear as to what the basis of the alleged perjury was. And I will stand on my argument that if the court believes in any way that the indictment itself was deficient, I believe that a bill of particulars can cure that.
A couple of other questions. You referred to, at least I believe what you're talking about is the return of the indictment in April of 2023 that was done before the Superior Court in Kenai. Is that what you're referring to?
Yes, Your Honor.
And that was where the argument at least was laid out that potentially there were, at that time there were 11 grand jurors, and that was laid in front of the Superior Court judge down there at the time, right?
I believe the record reflects that. That was my intent, Your Honor.
And the record, I think, also reflects that the judge indicated that that ought to be addressed by motion, and here we are.
That's correct, Your Honor.
And so here we are on that point, correct?
Yes, Your Honor.
To the point that I think you've raised that the grand jury lacked the 12th juror, are there steps that have been taken, or are there steps that could be taken because the grand jury has not yet been discharged to secure the attendance of that 12th grand juror and remedy the defects that have been outlined in the motion practice?
Your Honor, I assume that question was directed to me, and I will answer that. I believe reasonable steps were taken in April 2023 and subsequently by the jury clerk in the Kenai court system, as well as officers from judicial services, to try to locate that 12th juror and to implore him to continue his service until completion. Those efforts were unsuccessful, and as Mr. Patuminos suggested, there was some discussion among the grand jurors about other steps that could be taken. Ultimately, they decided with my counsel not to take any, or not to suggest any other extraordinary steps. For example, having him arrested or having a citation issued or anything like that.
All right. Anything else that you wanted to clarify in response to my questions, Mr. Campion?
No, Your Honor. Thank you.
Mr. Patuminos, any follow-up?
Yes. Behind Mr. Campion's remarks is a fundamental misapprehension of the rules of government here. It is not that the grand jury sought to set anyone up. It is that in order for a perjury charge to issue, as the United States Supreme Court and all the federal courts and all the state courts that have considered the issue have said clearly, and set forth in our brief, there must be a specific and clear question, a specific and clear answer, and sufficient evidence of its falsity for a perjury prosecution to ensue. So it's not that you tried to set someone up. It's that you need to have the proceedings in front of the tribunal that are required to match the elements of a perjury prosecution. The laissez-faire role that the prosecutors took in these grand jury proceedings are unprecedented. It is not for the grand jury to decide for themselves with no help and no member of the bar with a license and with a code of ethics and all that goes with it to run off willy-nilly by themselves, because that is the role under the minimum standards set by the bar, by the ethical code under which we all operate. And it's a tricky business, because when a prosecutor is in there by himself, he is in an ex parte proceeding, isn't he? And it's his obligation or her obligation to make sure that the sword and the shield are in balance and that the law is followed. You don't stay back and say, whatever you grand jurors want to do, because the grand jury is a judicial tribunal. They don't have law licenses. They have to rely on the law as given to them and the judgment as given to them by the prosecutor. And much has been written about this. So behind Mr. Campion's comments are this notion, I was just there assisting the grand jury for what they might want to do. That's just all it was. And you read Order 1993 and it lays it out. And it's not news. It's not new. The prosecution function, the executive function of the executive branch of government, brings to the judicial body, the grand jury, its case. And if there's more to investigate, they investigate. And the guardrails and the constraints and the careful conduct of those proceedings are the responsibility of the executive branch. When I was a prosecutor, there was a term called runaway grand jury. Maybe you've heard of it. A runaway grand jury is a grand jury that takes off on its own, violates the law, does whatever they want, and the prosecutor can't stop them. You know what happens? 5 minutes after the grand jury issues its indictment or result, the executive branch dismisses the case and it doesn't have to ask anybody. Because it is an executive function to prosecute, a judicial function to review the material, and then it's an executive function up until a plea of guilty is taken or until a jury verdict is returned by the petty jury. The prosecution doesn't have to ask anybody. And this notion that the grand jury can run off on its own and do whatever it wants, and the executive branch is powerless to stop it, is simply wrong and scary and frightening. And that's why I hope you don't just write an opinion saying, oh, 11 grand jurors, too bad, because there's so much at stake here. Thank you.
Thank you, Mr. Timinos. All right, folks, that concludes the arguments for today. As I indicated at the outset, my intention is to review things thoroughly. I will be issuing a written opinion in this case. I'm not giving an answer here today. My expectation is that I will get that opinion out in the next 30 days. I would like to set at least a follow-up hearing to keep this case on track. Next phase, if the motion is denied, would be a trial setting conference, and so let me set it on, if I may, February 22nd at 10 a.m.
Yeah, that works, Judge.
All right, Mr. Campion, February 22nd at 10 a.m.
That's fine, Your Honor, thank you.
So that'll be our next hearing. I see a hand up in the back, and folks, this is not a time for question and answer. So unfortunately, I can't answer further questions. This was just an argument among the lawyers today. Thank you for your public participation. I understand that there's interest in this case. I'm glad that we had folks here. I will be issuing a written opinion as I've indicated. That will be a public opinion once it's issued. But those will conclude the proceedings for today. So thank you all for coming. Stay safe, everybody. And we'll be in recess. That'll conclude this proceeding.
Goodbye.
All rise. All rise. The defense's argument is that the grand jury has no right to investigate the judicial branch. And citizens of the United States have no right to have accountability. Only people in power, those that they work for, have that right. Which basically what in my opinion, holds on what the argument is today. Thank you for being here. Really appreciate it. Like and share this video, please do that right now. Find us on YouTube, Twitter, Facebook, and Rumble. We're always talking about our website when we are live. I understand the live stream that came out from the courthouse was unintelligible. I had multiple messages telling me that the link that I had provided to be able to watch the Zoom on the courthouse's website was not playable. You couldn't make it out. It was crashing left and right. So if you caught it live here, please like and share this video because you're not going to see this uncut and unedited anywhere else. Mainstream media is here. You'll get their 30-second take on the nightly news on what happened here today. And if you want to know what really happened, unfiltered, uncut, and they face your own opinions, this is the way to do it. Like and share this video and show your friends. Thank you again for being here. We're going to go step on outside and hopefully just come over to the full screen.
Who are you with?
What it is.
What it is?
Yeah.
Heard of you.
Thrilled to see you. And so thrilled. No, good job. Okay, we'll get to it.
Well, I filed the opening brief.
You see that shit? He actually freaking signed it. John Doe. Put down John Doe. Hey guys, News in Alaska here. Thanks for watching. We're at the courthouse in Anchorage, Nesbitt on 4th Avenue. I'll explain what's going on here in a little bit. We're going down to 1, right?
Yeah.
GoPro, start recording. look around a little bit. See what else they got here. Clerk's office. Somebody smells like alcohol. Thanks, man. Appreciate that.
Okay, thank you so much.
What's the difference here? Okay, thank you.
Oh, yeah. Yeah, I'm gonna email her, right? Thank you so much for all your help today. Good day.
You're good.
Pick it up, whoever's next. This was before you agree on everything, you get a court date before you walk out with the file. Or divorce is you agree on nothing.
Divorce.
Divorce, you have kids or no kids?
Can I help you at 3? Hello?
Would I be able to do it here if I had case I had extended
Do you have your board keys number? Okay, if you use any of these computers here, there's instructions on the counter or the table of how to look for your board keys number. If you need this number, you can use and then you'll, $5 today.
Can I help you?
So your pocket information, I gave you
Oh, okay.
Now, in 232, it's going to be filled out with black ink.
Good weekend?
Oh, yeah.
Awesome.
Still getting over. Saturday, Sunday. All right.
How you doing, sir?
Good, how are you?
All right. So I was told that you was granted permission to record in here. All I ask is please do not put my workers on your.
Oh, I'm gonna film everything, bro.
Say again?
I'm gonna film everything.
Please do not record me, sir.
I'm gonna film everything, bro. That's kind of the whole point, right?
Say again?
I said, it's kind of the whole point, right? And actually, I only had permission in the courtroom.
Say again?
I said, I actually only had permission in the courtroom.
You only have permission to do it
Film in the courtroom?
in the courtroom only?
That's what they said, yeah.
Okay. So that,
Did somebody tell you different, or?
no, I was told that, that you have permission to film.
Oh, from the judge?
I guess, I'm not sure. I'm just asking,
That's cool.
personally,
Yeah,
to not put me on your video.
okay. Well, I'm live, so.
Okay, well, please don't put me on your live.
I'm live right
Please
now.
don't put my employees on your live.
They're already on it. Hey, Eric, you got that piece of paper?
Oh.
What kind of case? Excuse me, I'm not sure you can be recording me.
Hey Sarah, how's it going?
Good, how you guys doing?
Not too bad. So I was there when Mr. Clerk gave you the form to film into the courtroom, right?
Mm-hmm.
Yep, that's totally fine. But they did specifically say that was just for the courtroom.
Mm-hmm.
So right now you can't be filming this. So right now you're walking around.
So why can't I film in the courthouse?
Because there's.
Here, let's go out here.
Actually, no, we're gonna stay right here.
No, we're gonna go out.
We're gonna
Are
stay right
you,
here.
are you stopping my
Are you
movement?
leaving?
Are you stopping?
If you
Are you
wanna
telling me
leave,
I
you
have
can.
to leave?
But we're trying to talk to you. Right
So you're gonna stand in my way?
No, if you want to leave, you can leave.
I'm standing in my way, you understand? Stop my freedom of movement.
So,
What's your
here's
name,
the deal.
badge number?
Officer Munson, badge number 99. So
What was your name? Manson?
Munson.
And what's your name, badge number?
Officer Yang, 101.
And you guys are court
Services officer.
judicial services, right?
Yep. So,
Okay.
there is, the rule of the court. They
Here we go.
recently put it
Let's hear
out. It was like midsummer. Well, yeah, so it's relatively new, but you can't film the public areas of
Is
the
it a law,
courthouse.
is it a law or a policy? I don't follow policy, I follow the law.
Policy, it is law.
You just said policy.
It's a court rule. It's a court rule.
Court rule is policy.
Set up on No, it's a law.
Court rule is policy.
I can. Yeah,
Who-
we're still required
Who
to
made up
enforce
this
it.
policy?
A judge.
A judge can't make laws, they can
Well,
rule
and-
on cases, but they can't make law.
That's why
laws.
it's a
I have
court rule.
I have a First Amendment right to film in this courthouse, in publicly accessible areas.
And I
have the
understand
right,
that.
I have the right to film my government officials in the course of their.
Yeah, sir, that's fine, but then you have to go through the process to get that paper signed off, like how we
The
did.
Constitution doesn't say that I have, so I agree in the courtroom.
Yeah.
Okay, that's why I filled out that form.
Gotcha.
I don't agree in the publicly accessible areas of the courthouse. I have the First Amendment right, I have the First Amendment right
It's just for the
to
protection
film my
of
government
privacy.
officials in the course of their duties. There's case law on it.
Okay. I totally understand, and I agree with you. We're making contact with them, where I post one now. Yeah, and I get it too, like, it is.
Well,
makes
if you
sense
get it,
as
then
a
you wouldn't
First
be,
Amendment right, but
if you
they
get it,
still-
then you wouldn't be harassing me.
They still have the right to make.
I have the right to go around quietly and film this building that we pay for.
How's it going? It's going. Judge Matthews gave him a court order signing off that he could record in courtroom 401. However, this gentleman is just going around recording the court campus and things like that, which, according to the presiding judge, that is against the rules of the court.
Do you have the permit that they gave you to film in the courthouse
do.
today? Can I take a look at it? Awesome. So it says common areas of the court facility located at. It didn't specify the location. January 8th, 2024. I can't read what that says, something only. Maybe hearing only? All right. Did you fill this portion in, or did the judge fill that portion in? Do you remember? Right here?
Ruled by court.
Okay,
This
so,
line down
so this
says
section here
court.
was, okay, gotcha. Yeah, I can't really read what that says, but it does say,
But regardless, I have the First Amendment right to film in this publicly accessible building.
well,
As long as I'm peacefully, quietly filming, there shouldn't be a
the state
problem.
constitution gives the presiding judge the ability to set the, what's allowed as far as recording and.
It's federal law.
within
You're
the
telling
building.
me
So-
that the judge can go over federal law?
Well, it's not going over federal law, but it is.
Federal law is federal law. That
It is laid out in the
supersedes-
state constitution.
Federal law supersedes anything the judge would say.
For this, right now, I don't see where it says you can't film in the common areas. So I just ask that you stay out of the way of the people that are coming and going, and just don't interfere with our.
I don't need
with
your
our-
directives. You
with
guys
our,
can, you guys can go, you're
security here.
dismissed.
Okay. Huh?
And you need to keep your hands off people and stay out of people's way when they're trying to move around.
So just
You
make
have
sure you're
no-
not.
You have no jurisdiction over people.
Make sure you're
unless
not.
they commit a crime.
Make sure you're not.
Is he a regular state trooper? I see you're in blue.
Make sure you're
Do
not
these guys
interfering
have,
with people
do
coming
these
and
guys
going
have
from the
arrest
court,
powers?
They do on court campus, yes, sir.
Okay, but they're not like you are. You're in charge, right, over the judicial
I
services?
supervise them, but they do have arrest powers on the court campus.
Okay, I was trying to leave that area in there and he stood in front of me.
Okay.
And blocked me from leaving. I don't appreciate that.
I did open the door afterwards.
Well,
Afterwards.
like I said, just avoid, just make sure you're not interfering with people who are coming, going for business to the campus today, okay? All right, thank you, sir. Have a nice day.
What was your name? Sorry about that.
My name is Sergeant Bitts. What's your name?
Biggs? And your
Bitts.
badge number?
It's 143.
143.
All right, nice to meet you.
Yep. Tell me what to do. That didn't work, did it, bro?
Sir, please do not record me. You don't have the right to record me, sir.
Oh, now I'm recording all you guys.
Please don't record me.
Now I'm recording all you
So
guys.
you invading my privacy and
You don't
my
have the
rights.
right to privacy in public, bro.
Say again?
You do not have a right to privacy
Isn't
in
that what
public.
you just explained to the officer?
You
That
do not
have
have
the
a right to privacy
I
in
do have
public.
the right, sir. Please
You
don't
do not,
record me.
you do not have a right to privacy in public. You are in a public building, working as a security guard. There's cameras all over this building. You're on camera all day, dude.
It is gonna be on the news.
What's that?
I say it's gonna be on the news.
No, not something kind of like that. You're good.
Yes, that is true. That is true. So, you jacket, you're gonna go to customer service, and they'll
This dude's so triggered over camera. Is that your guys' supervisor back there? What a,
Exit.
what a freaking clown.
Thank you. Have a good one. You too.
Sir, can you please go that way, please? I'm on the phone. Can you please go that way? Sir, can you please walk away from me, please? He's in court. Yes. How you doing? This is
Satoshi, you're funny, dude. I like it. Do me a favor, guys, hit that thumbs up button. Subscribe, like, and share. Really helps the channel out. Helps the algorithm. Yeah, share my videos with friends, family, coworkers. Everybody. Share, share, share. Are you still going on about me, bro? Jeez. He's still freaking out. Like,
Hi, sir. How are you?
I'm great. How are you?
It's nice to see you around.
Yeah? You know who I am? Appreciate you. Huh? Oh, on the docket? Yeah. I can't believe he's your guys' supervisor. Maybe one of you guys should be promoted. Oh, I got smiles off that one. Oh, I got 3 of them. Oh, yeah, guys. Dude, he is so ticked off, guys. Look at this. We'll zoom in. Oh, and he walks out of the frame.
I thought you had a case. Hello. Oh, Brian, you? Yeah. That's good, that's good. So
shine up again. There's no sun. See, you can look at it. Joy. I left the islands for this girl.
You left the island for this, huh?
Yeah, you know, starting to feel regret over here.
Man, this only lasts 3 months.
That's good, that's good.
Yeah, it'll be a fur runner group coming up. You know, hey, spring.
Stay out of trouble.
All right, man.
Hello. You know where you're going? All right, are you bored?
I can do that one.
Hey, right around the corner. If it's not there, then come back with your. Yeah, of course. Good luck.
Thank you.
Yeah. Close the doors.
Excuse me.
Excuse me. Hey,
This is
you
not
guys
a
provide
this
service
is not a
here?
common area, sir.
Yes, it is. It's
No,
an
it's
office.
not.
Sir, it's not a
I have a-
common area, sir.
This is where people come and conduct court business.
I have court business. I have a question
Excuse me.
for whoever's in charge.
So let me show you where the common areas are, sir.
I already know the common areas are.
Sir,
Dude, don't
this
get in
is-
front of
this
me,
is
bro.
not the common
Don't get in
area,
front of me,
sir.
bro. It's not gonna work out great. Please get
Please.
on. Please get out of my way.
Please get your camera out of
Please
my
get
face,
out of my
sir,
way.
please. And I'm gonna show you where I'm gonna show you where the common areas are, but this is not a common area, sir. This is not
Appeals division.
This is not considered
Appeals
a common
division.
area, sir. You have permission to record in the common areas. This is
This
not
is a common area. It's
sir.
an office.
Sir, this is
This
not
is
a
an
common
office.
area, sir.
This is an office.
An office is not a common area, sir.
I'm not gonna argue with you, dude.
Alrighty, please close the door. So
No,
can
I need to talk to. I need to talk to the staff here. I've been waiting for someone to come up. I've been here 3 times, and no one's come up to talk to me.
Sir, you have to wait in the common area, sir. The common area.
No, I need
is not the-
services. That's why I'm here. I've been here 3 times.
Sir,
And she finally came out.
the common area, she's talking to me, sir.
Well, I need to talk to her or
Okay,
her
so
supervisor.
hang
Who's
tight.
your supervisor?
Hang tight, sir.
Okay, I'll hang tight right here.
Can you let the door go?
No.
Sir, please remove your hand from the door. Please remove your foot from the door, sir. And please get your camera out of my face.
Get your face out of my camera.
My face is not in your camera, sir. You're interfering
Can I talk to
with
the
my duties,
Can I
sir.
talk to the supervisor that works here, please?
You're interfering with my duties.
Dude, you're security. Get out here and secure something.
You're interfering with my duties, sir.
I'm not
Please
interfering with nothing.
Step away.
Ma'am,
Boss, you got to call somebody.
This is an office. It's a publicly accessible
Sir,
office.
please go to the common area, sir.
I would like to talk to somebody in this office.
Right now, I'm conducting business in here, sir.
So am I.
Okay.
We both can be in here connecting business at the same time. It's a big enough office.
Sir, but you can only record in the common areas.
This is a
not
common area. It's an
area.
office.
It's not a common
It's an- I'm
area.
not gonna argue with
An
you.
office
It's
is
an
not a
office.
common area, sir.
Yes, it is.
No, it's not. It's an
It's
office.
a publicly accessible office.
It's not a common area, sir.
What's up, man?
Is this small claims? Where do I go to small claims?
Right. How you doing?
Like I said, common area. Hey, I'd like to talk to somebody in this office. I'd like to talk to somebody in this office, and he's kind of in my way again.
Okay, just received a report that you're being belligerent, sir. What's going on?
Because I've never like gone through this before, like the process and like
Hey, can I get a public records request?
You need to go to the customer service counter for that, please.
Okay, can I get a complaint form too?
You can get that at the customer service desk.
What about on you guys?
I hear you.
I don't have any back here. You can
You
get one
don't?
at the customer service.
Okay. And where would that be? Customer service, like the clerk's office, or
Right over there.
is it the clerk's office, or?
Matt, can I touch you?
Mhm.
Awesome.
Would you mind not recording our?
Yeah, I'm not here for you guys. What a freaking joke.
Sir,
Yeah.
were you filming a civil matter going on in there?
I was asking the clerk for a public records request and a complaint form.
Okay, yeah, that's just what they were just concerned about because those people were conducting business.
Yeah, and I left.
Okay,
To
gotcha.
show them respect. I'm not trying to film them, I'm trying to film the government employees.
Gotcha.
Right, and when they leave, I'll go back in there and ask them for a public records request and a complaint form.
Okay, fantastic.
Pretty simple.
Okay, gotcha. So I looked over your court proceeding. I talked to the presiding judge, Judge Matthews. He was the one that signed off on your paperwork right there.
Was that Judge Matthews?
Yep, that was Judge Matthews.
Does he print his name on it?
Yep. On the bottom there, it says recording only for the court proceeding.
Okay. Do you guys have a copy of this?
Yep. Right there
Oh,
on the
there's his
bottom.
name right there. Okay, Thomas Matthews.
Yep.
Where at?
Right there on the bottom, it says January 8, 2024, hearing only, granted.
Where's it say for hearing only? I don't see it.
It says hearing only, January 8, 2024, granted by the judge.
Hearing only.
Yep.
Was that what the judge said?
Yes.
Hearing only? Okay.
Gotcha. So you can hang out, that's totally fine. But you gotta have to turn off the camera.
I'm not turning my camera off.
Okay, gotcha. We're gonna have to ask you to leave
Why do you have to ask me to leave?
because you're recording and breaking court policy.
I'm what?
You're breaking court
I'm
policy.
sorry, I'm hard of hearing. You gotta-
Yeah, you're breaking court policy by recording and everything like that.
policy?
Yep.
Do we gotta go through this over again?
Yeah, that's the court
I have the
rule.
First
That's the
Amendment
court
right.
rule.
I have the First
Gotcha.
Amendment right
Gotcha.
to film.
I understand.
My government, there's case law on this.
I hear you. We also asked you to not interrupt the folks working and things like
How am
that.
I interrupting?
While you were recording.
I was talking to the lady.
Yeah.
That's not interrupting.
While somebody was trying to get a
She
civil
walked
proceeding.
away with you. The conversation ended. I left the room.
Okay, gotcha.
So how am I up here disrupting? And you better be careful because all this is recorded. I'm live right now.
I hear you.
So-
I hear you. But you were recording a civil matter going on. In
No, I
there.
wasn't.
That
I was
private.
recording my interaction with my government official.
Yeah. Gotcha. So right now you're just waiting to go back inside.
Yeah, I need to
get
talk to her to get a
complaint
public
document.
records request and a
Okay,
complaint
gotcha.
form.
Okay, gotcha.
Yep.
Um,
I've been in there 4 times, and no one's come out to talk to me.
okay, and that's all you need?
Yeah.
Okay, and then are you
Complaint.
going to leave the court campus after that? Or?
I might go upstairs and check some stuff out, but that's pretty much it, yeah.
Okay, gotcha. Was there like a supervisor that you need to talk to?
At this point, yeah, I want to make a complaint.
Okay.
I mean, no one's coming out to talk
With the
to
civil
me.
office?
Yeah. Yeah.
Okay, gotcha.
And they deal with small claims and some other stuff, right?
Yeah.
Yeah, I need a complaint form and a public records request.
Okay. Well, I'll go talk to them. Let's see what she
I'm
says.
not here to start crap. I'm just quietly trying to film.
I hear
Every
you.
time I have an interaction, I'm approached.
I know.
If nobody would walk up to me, I wouldn't be talking.
Gotcha. Gotcha.
So,
All right. Well, I'm gonna talk to the civil manager.
okay. Are they still in there? Or?
Yes. They are.
Yeah, I'm not here for them. What they're doing in there doesn't matter nothing to me. So. Dude, these people are so triggered over a camera. You have permission, you don't have permission, you have permission. Make up your freaking mind. He's in here. Yeah. Enjoy. Yeah, man, you too. Hey, can somebody in the chat put up what time it is?
You don't know what state they're in? Yeah, I emailed it. Okay, did you try to hire a process server? Did you attempt to hire a process server? Did you follow the instructions on hiring a process server? Okay, so you have it unsigned, you have an unserved document from the process server you tried to hire?
Thank you, Satoshi. Appreciate it.
Okay, did you try to hire a process server? You didn't pay them to do the service.
I think my parking meter is up, so I gotta go, but I want a complaint form on a public records request form.
And you tell the judge that the process server tried and exhausted all resources, and then you file a diligent inquiry, which is a web posting, but that has to happen. A notification or certified restraint, delivery, return, with an envelope that's not signed, it's returned. But you have to exhaust those two resources, and then you file for web posting. Then a lot
Come on.
you'll have to do it again.
These people are so stupid.
So that's the gist of it. Judge needs to know that you effectively tried to find and locate this person. The other parent, then you have to try and serve on in a jail facility. Yeah, there's a way.
When I try to go talk to my supervisor, and I walk down, and he follows me, he's disturbing me. And I asked him several times, and I did before, I asked him not to follow me, and he continued to do it anyway. So now I'm feeling harassed.
From the, anywhere that the public can go, he has the right to film it, he's got
Well, my phone calls aren't public.
Gotcha, and you understand that once people are conducting official business and whatnot, you're to not record them, right? That's
Technically I can, but I'm polite enough not to.
okay.
That's why I left that office. Let's not get it confused, okay? Let's get to the T, let's dot our I's and cross our T's. So what's going on with this office here? Are they gonna bring me a complaint form, or?
They don't have any complaint forms for you.
They don't have any complaint forms or any public records request forms? Nothing like that?
You can try asking them.
They're not gonna come out and talk to me. All right, well, I'm gonna jam, man. We'll figure it out later. I got other things to do today. You guys have a good day. Hey, thanks for being polite, man. What was your name?
Officer Yang.
Officer
Yang.
Yang. Thank you, man. I appreciate you.
Yep, take care. James.
You guys have a good day, man. Appreciate you. You guys have a good day.
All right, have a great day, man.
Yep. Do better next time. Oh, wow. That's pretty cool. Yeah, dude, they got a lot of cool stuff in here. All right, well, that was, I don't know, it was all right. Wasn't the best. I think our time's up on our meter, that's why I want to go. Yeah, it's like 30 minutes past, so I really don't want to get a parking ticket. So, all right. Hey, thanks for joining me, guys. Let's see if I can flip this around. Whoa. Hello. Hey, thanks for joining me, guys. Yeah, so what that was about was there is a judge that a corrupt judge, they found a bunch of corruption that she had done. She had retired, and I guess they looked into a matter. I'll put it up when I cut this up and make a video out of it. But this court hearing today was about corruption, about a corrupt judge, and she had been covering up, falsifying documents. Anyways, all right. News Now Alaska signing out. Thanks for joining me, guys.